Awesome, awesome. So now I want to move on. We had a lot of discussion around some of the things we talked about last time, so I want to deep dive into them. So Brian, in our last conversation, we touched briefly, we talked a little bit about instances where you get a bad evaluation and you had just successfully defeated this evaluation and had it thrown out. So I want to take a step back, and this is something that a lot of our viewers, that a lot of dads go through, are these evaluations. So when in California, they're called 3111 evaluations. That's the code. That's the family. That's the best interest of the child part of the family code. What are they? Is there any specific name for them in Oklahoma?
Yeah, here what the term that's usually used is like a guardian ad litem appointment and investigation. And I think you had mentioned about what you can do to get your best foot forward on that. In my experience, first of all, I think you want to be as direct and honest with the guardian ad litem as you can. If you have something that you think they need to know about, it's probably better to tell them up front. And if there are negative facts that they're likely to uncover, I think it's better for them to hear it from you than have it be uncovered later by some other person, especially somebody who does not have a dog in that fight. Because if you acknowledge, yeah, okay, yes, I made this mistake, or this happened, or that happened, it takes the sting out of it. There's less, you don't have the effect of surprise. I mean, the same can be true with judges as well. It's usually if you know you made a mistake, you know it's coming out, you're always better to acknowledge it up front, as opposed to waiting for the other side to bring it out, and you can sometimes take the sting out of that.
Or getting it sprung at a hearing. That's always the worst, when you have a bad fact get sprung at a hearing. So let's dive deeper on that. So there's a bad fact in the case. There's a drug arrest in the recent history. There's maybe a domestic incident that's occurred. There's been a CPS investigation. When you have that guardian who's an attorney and not a trained social worker, how would you advise your clients to address these bad facts? We obviously want to put it out there, but what is the advice, the tips when they're going to have these conversations? And are attorneys allowed in these conversations with gals in the state of Oklahoma?
You got to be careful here, because if you caught a DUI, you're obviously not going to give any incriminating evidence. If you caught a drug charge, you're obviously not going to give any incriminating evidence. And all of that's going to come through the attorney. And it's not going to be writing. It's going to be a conversation. Right? I mean,
absolutely. And I think to some extent, how you deal with it depends specifically on what stage you're dealing with in terms of, like, if you're becoming something criminal, depends on what stage you're dealing with in the criminal process. If this is something that you are accused of that has not been adjudicated in the criminal courts yet, he's right. You want to be very, very careful what you say to that GAL, because it could be a potential witness against you. By the same token, though, if you have a situation where facts are likely to come out that would tend to cause the GAL to conclude that you probably did what you're accused of, there is something to be said, especially in the case where if you have entered a plea, you have been convicted or whatever, there's something to be said for the idea of, okay, owning, yes, I did make a mistake. However, here's what I've done to turn from that mistake, and this is why it shouldn't be the end of the world. And I think it's also worth being aware of what are the specific facts of it. Not all, and it's not to make light or minimize domestic violence, but not all domestic violence cases are created equally.
The other thing that you really ought to point out here is that sometimes guardian ad litems are used by some people to weaponize the court system.
Yes.
Now, and sometimes we get into cases where a particular guardian ad litem with a particular relationship with, one lawyer or another, is appointed, and it's problematic.
Mm-hmm.
The appointment process of a guardian ad litem is extremely, extremely important. And frankly, most of those orders are agreed. And so you should have some kind of a say in who the guardian ad litem is.
Mm-hmm.
In the case that we were talking about where Brian was able to basically disregard the Guardian Ad Litem's evaluation at trial, that particular Guardian Ad Litem had very clear biases based on her receipt of certain evidence from one party and lack of recognition of evidence from another party, and then conclusions that were made based on that, which was very easy for Brian to impeach.
Yes. And I would note too, in that particular case, I had filed a couple of motions, both asking that she be removed and also asking that any evidence she generated as in the report be excluded. And although the judge did ultimately allow it in, it did have the effect of causing him to look at it harder. And
building the narrative.
Right. I think it's worth pointing out that even if you don't immediately get the relief you asked for in the motion, sometimes it's worth pursuing that argument anyway, because it has the effect of causing the judge to look harder at the evidence, and that can still pay dividends later down the road if you do end up at trial.
Yeah, that's something that I talk ad nauseum about with clients is we may file some things, we may file declarations that we know aren't going to get granted, but it's going to put it on the judge's mind. And I'll give a very specific example. In California, one of the counties, Orange County, that I practice in, we still aren't in person for hearings. That's still about a month off before we're back in person. And the other counties out here, it's been the middle of the summer was when things started picking back up and going in person. And so these judges haven't seen some of these people in person the length of their entire case. The other morning, I brought up in front of the judge, I said, it was actually the judge who technically is presiding over my case. And I was like, hey, Your Honor, I need to do some housekeeping. My case is technically in front of you right now. So I want to make sure you're okay staying on the case. And she went on the record and she's like, I have no idea what your personal situation is. Just so happens I'd never been in front of her professionally. She was like, I have no idea who you are. I have no idea about your case, anything like that. My case has been in front of her for 2 years.
That's a huge due process issue, Mark. And every time that they asked me to do a hearing virtually, I told them, frankly, that it was violative of my client's constitutional rights because the public deserves to be here watching you, judge, do your job. I mean, otherwise, what are we doing? We're having private courtrooms. We're having private. I mean, this is absolutely insane. The COVID protocols that have been put in place need to be checked by counsel in every sense. They are public officials, and the public needs to be there to watch them. I mean, otherwise, what are we doing?
I will say, yeah, go ahead, Brian.
I'm sorry to jump in there. I was going to say that is how we keep the system honest, is with public scrutiny. I think the other thing too is in some of these virtual hearings, you can almost analogize it to be the equivalent of putting the courtroom in the back of like a flatbed truck, driving it around the city a couple of times, and then having court. Because I've had several hearings where you have like different login credentials, they change by the hearing, and it creates a situation where you actually have a problem with accessing court for the purposes of seeking justice.
Mm-hmm. And then they are able to exclude family members and other people who are interested. I mean, it's ridiculous.
It really is.
That's one of the things that's been a struggle. I mean, there's still, in California, there's still a ton of restrictions. Many judges have created their own rules where it's the attorney, the client, and then typically the party, the client, can have one support person. And they have these very strict rules around it. So that's something I agree with you guys on that. The one positive that's come of it is the improvement of technology used by the courts. So out here, there wasn't live streaming of court hearings. There wasn't any of that going on. Now we go through COVID where it was forced. We had to do some things online. And now all of that technology has been integrated. And I'll one up you. Riverside County out here, they didn't do video hearings. They did telephonic hearings for about 16 months. Telephone. You dialed in, and then they called they would check in by what was your last 2 digits of your phone number.
I'll posit the Ninth Circuit would have had a field day with that.
Yeah, it's one of those things where it is very challenging because the landscape's very different. I mean, I don't know if you guys have seen what happened to the only In-N-Out in the city of San Francisco got shut down because they weren't properly checking for COVID vaccination cards. So there's been out here, the challenge has been been a great deal of, I believe, overreach by the government that's infringing on I think family courts talking about some of the most important rights and liberties that someone has as a human being.
And where do we go, Mark? We go to the courts, which is the most profound problem, right? I mean, where do you go to address that sort of an issue? And it's the court that's creating a rule that is violative of fundamental due process.
Yeah, I mean, I don't know how you guys had it out here. We had 6 weeks where the courts were shut down. There was very little remedy. A couple of the courthouses. I'm based in Riverside County. A couple of the courthouses were, up until probably about 3 months ago, were only open for domestic violence issues or emergency ex parte hearings. They were not dealing with anything else.
We did have in effect of the way that the courts have scheduled since COVID in prioritizing hearings. We have certainly seen a delay for issues that are not a protective order, emergency custody, or a motion to enforce visitation. Now, albeit I'll say, I can get a judge in front of me on an application for writ of habeas on an emergency, and I can get a hearing in 21 days for a motion to enforce in Tulsa County. And I believe that these judges recognize those underlying fundamental visitation rights and are prioritizing them, which I'm very thankful for. As a father's rights practitioner.
Yeah, I mean, we'll give them credit. They are trying to prioritize those things as best they can.
They are.
I mean, they are, and it's a tough situation because the calendar has been all jacked up for about a year now because of this kind of stuff. So getting hearing dates, if it's not something that's high priority, we're looking at a considerable wait.
And we are not in the business of qualifying bullshit, because obviously you don't want to throw a dumb emergency in front of a judge. So it's for some folks it's definitely prejudicial.
Yes.
Yeah, I would say out here, I think the biggest thing is they've prioritized, because we do essentially, there's the morning court call typically, where it's the short, you're going to have 5 to 25 minutes in front of the judge, and then typically most judges set long form hearings in the afternoon. I think the biggest issue out here is a lot of judges have prioritized and are doing court calls in the morning and the afternoon, and it's situations where if you need a long form hearing, then you may be, I just had one that got set 6.5 months out. That was the nearest date, and that was for a 1 afternoon hearing. That was the earliest that issue could be heard. Now, on what? It was essentially, it was a request to modify. When we have temporary orders, they can get modified as many times as the judge deems necessary. But whenever you request that, I think last time we talked, you guys, it's the temporary order gets set, and you're stuck with that until you go to trial. California, not at all like that. The 2 counties I'm primarily in, it's very rare to go to a final trial. Just financially, it doesn't make sense for the people. Usually, you press the issue until you get to that point, and then they basically tap out. in terms of what happens. Now you get over into LA and Orange, very, very different. But yeah, that's been one of the biggest concerns is when you do need that long form hearing, you do need to put witnesses on the stand. You're probably going to be 6 months out.
Wow.
Yeah.
That sucks. I mean, I don't think it's quite that bad here, but you could be looking at a 60 to 90 day wait to get get some of these kind of hearings, even like with temporary orders.
I think the fastest day you're going to get a trial date is probably 120 days.
Yeah.
So 3-4 months, 4 or 5 months, you're going to get in front of a judge for that long form.
After your temporary order, yeah.
Yeah, and that's always assuming that there isn't some unforeseen delay.
I mean, if everyone's playing ball discovery, there's no legal issues, yeah, you're going to get you can set a trial date probably about 120 days after a temporary order. But, I've also seen it go 2-3 years, so it's always.
My thing with all of this is that if judges had urgency in handling these matters, I feel like the longer these issues go on, the messier they get. If we had a system that could put you in and in 6 to 12 months have you out with a resolution, that would solve a lot of the messiness that we end up seeing in family court.
Well, yeah, and let's talk about the statute and status quo, Brian.
Oh, yeah. I mean, one of the problems is if one party gets a favorable decision on temporary orders here, it incentivizes, pardon the expression, it incentivizes ass dragging, because what you run into is you get a situation where if they can establish a status quo where that situation's been the case for long enough, you're looking at a situation where the judge is going to look at the other party and be like, all right, tell me why I should disrupt this. Incentivizes ass dragging.
Mm-hmm.
Yeah, I think that's something you see in California, but you can go in and change, and the judge you can bring, even if it doesn't change something right away, you can start to build that narrative of, hey, one party's not being cooperative and this is why. And then you go back a couple months later and say we're having another issue and potentially get some change. But I can see where the one shot and then you got to go to trial to get a change, how an attorney will pull out every trick in the book just to drag their feet to prevent being ready for trial.
Now, technically, under the law, you're not only required as a judge to have one. It's a instrumentation of theirs, effectively, in order to.
Yeah, I mean, it's a funk. I don't know that it's so much of a problem in the more rural counties in Oklahoma, but when you're talking about like Tulsa and Oklahoma City, or particularly Tulsa, what you're dealing with is you have incredibly busy dockets, and if you try to go back for another bite at the apple on a temporary order, first reaction you're liable to get from a judge is, why do I need to relitigate this? And if you don't have a pretty damn compelling reason many times means there's some kind of an emergency, then they're just going to be like, nope, set it for trial.
An important thing to note here in Oklahoma is also that when we decided how many judges we were going to have, we didn't have protective order dockets. We didn't have the federal implementation of Domestic Abuse Act, and so the amount of judges that we have is frankly prohibitive in many ways, and we need more judges. I mean, particularly in family court, we need more judges.
We really do. I mean, that's why we get so many special judges, because the courts have a little bit more leeway to appoint special judges than to create like a new district judge position or a new associate. But even still, you're absolutely right, Keith. We're extremely short-staffed when it comes to judges. And then the judges' support staff, it's the same problem.
I think that's something you probably see nationwide, is that the dynamics of the family and the dynamics of the rural family courts developed into playing is they're simply what was going on 15 years ago isn't what's going on now. the number of issues and the number of divorces, the number of, I mean, now in theory, if a child is born to parents who aren't married, that case is going to probably at some point need to be litigated, and those numbers are absolutely just going through the roof.
Whew. Yeah, you're right. Yeah.
I think there's a
So,
failure to appreciate too on the part of the public. If they're not in the system, they're either because they're a practitioner or because they get sucked into it because of personal circumstances. I don't think there's a full appreciation for how much of a problem this really is.
amen. I say the same thing. I mean, my introduction to it, I was a sports and fitness industry exec. I was a trained labor and employment attorney, and I had no idea the system existed the way it did until I ended up in it personally. And my first thought when I went to it personally was, oh, this is a court in the United States of America. This is going to be quick, easy, fair. This is black and white. And took me about 2 months to realize that is not going to be the case. But the general public, like you said, the general public, or unless you're a practitioner, which I don't know about you guys, I don't think I had a single person in law that I went to law school with that would say, oh, I'm going to be a family law attorney. So I think even a lot of attorneys who aren't directly involved with the system don't understand what goes on.